Okay, we are live.
Good afternoon, Your Honors. The matter before the court this afternoon is the case entitled State of Vermont versus Michael Williams, case number 25 AP 422. Representing the appellant, Michael Williams, is attorney Marshall Paul. Representing the appellee, the state of Vermont, is attorney Claire Byrne.
Thanks very much. Good afternoon, counsel. We'll hear from counsel for the appellant. First, of course, please start by introducing yourself. Identify your client. Proceed.
Thank you, Your Honor. This is Marshall Paul. I am the attorney for Michael Williams, and we are here on an appeal from a hold without bail decision.
Thanks very much. Thank you.
Thank you. And from our perspective, this is a straightforward error correction appeal. At the weight of the evidence hearing in this case, the court issued a decision long after the hearing holding that the weight of the evidence was not great, but then continuing to hold Mr. Williams without bail pursuant to the state's 7553 motion to hold without bail, nonetheless. And Section 7553 is very clear that if the weight of the evidence is not great, then the defendant shall be bailable under Section 7554. They essentially have the same status if they're a 7553 defendant, but the weight of the evidence is found not to be great. They have the same bail status as a defendant who's charged with a nonviolent felony or with a non-sealable misdemeanor, which means they must be given bail and conditions. And so from our perspective, this case simply needs a remand for a new hearing. And I think I was incorrect in my briefing. I asked for a remand for a bail review hearing. And I think on sort of further reflection, that was the wrong remedy to request because a bail review hearing under 7554D is specific to cases where people have already had conditions in bail imposed under Section 7554. And that's not the case here. Mr. Williams hasn't really had the benefit of a 7554 hearing. So I think I think it's kind of technical, but I think the more specific, correct request for a remedy is for a remand for a 7554 hearing in the first instance.
Counsel, were there things in the trial court's order that granted the hold without bail that were suggestive that the judge felt the weight of the evidence was great?
The judge simply recounted the evidence and held that the weight of the evidence was not great. And from our perspective, that's consistent with the court's findings. The court showed findings, had findings that Mr. Williams may have had motive and may have had opportunity, but there was simply not much evidence, certainly not substantial and weighty evidence that went directly to the elements of the offense.
What about the neighbor? I'm sorry. Go ahead, please.
What about the court's determination that you hadn't met the 7554 factors, when that would only be the case if the evidence of guilt was great? That's the only time that would be your burden.
Or as we suspect, or as we sort of anticipate in this case, it's that the court made an error. Because I understand what you're asking, which is, what if the court actually found that the evidence of guilt was great, but its decision didn't reflect that? But we can only proceed on the text of the decision. The court could have filed a correction. The state could have filed a motion to reconsider. There was none of that. We have to go forward on the court's decision. And the court's decision is pretty clear that the weight of the evidence was not great. And that is reflected in the court's findings. The court's findings reflect a lot of circumstantial evidence and not much direct evidence related to the actual elements of the offense.
Did the
Go ahead. Go ahead.
The only thing I wanted to talk to you about was the video from the neighbor's residence. It seemed to me from reading the transcript that the video was entirely contradictory of what your client's testimony was. It did not evidence the deceased walking to the intersection. It did not evidence a red light on a vehicle that purportedly was picking her up to take her to another location. And in fact, it did show her white SUV departing the residence 40 minutes after she walked home. So how do you say that there was not substantial evidence? What do you say about that body of evidence?
I'd make a couple of points, Your Honor. First, I would make the point that that alone would not be sufficient to hold Mr. Williams without bail, because it may show that there's inconsistency in Mr. Williams' account, but that's different from affirmative evidence of his guilt, and that's what's required to hold somebody without bail. I would say secondarily, that's not that, first of all, that this court has been clear in matters of bail review that it gives great deference to the trial court's findings and determinations, other than its conclusions of law. And here we're talking about what weight the trial court gave to various pieces of evidence. And that's really a decision for the trial court to make. And this court's been very clear about the incredible deference that it gives to trial courts in those circumstances. So from our perspective, that's both a finding that's not, the trial court didn't make that finding, didn't find that that was itself probative of one of the elements, or at least not probative enough to warrant finding that the evidence of guilt was great. And also, that's not appropriate for review by this court in this context, because there has been no cross appeal filed. This hasn't been challenged. The court's findings haven't been challenged by the state. The court's conclusions haven't been challenged by the state. In fact, the state has conceded that the court's order was incorrect, and that the correct conclusion here is for a remand.
Counsel, is the state, to your knowledge, still pursuing the hold without bail request? After having read the pleading, I was questioning that.
I don't know the answer to that, Your Honor. I was not in the country until yesterday. And so during this part of the process, I've not had communication with the state.
All right, thank you.
If there are no further questions, I'll reserve the remainder of my time.
Okay, thanks very much. We'll hear from counsel for the appellee. Please, the same way, introduce yourself, identify your client, and then proceed.
Thank you. Good afternoon. My name is Claire Burns. I'm the Caledonia County State's Attorney and representing the state in this matter.
Thank you.
So as Attorney Paul indicated, the state has conceded on this point that solely looking at the court's order to hold Mr. Williams without bail, despite not finding the weight of evidence was great. I can find no precedent that suggests that such an order is valid. That if absent the weight of evidence being great, that is by clear and convincing evidence that the defendant must be bailable. I will note that on page 7 of the court's order, in the 7554 analysis, the court did characterize the weight of evidence as considerable, which is not the same as great.
So Ms. Burns, Attorney Burns, if I can ask a question, you are essentially confessing error, are you not?
Yes, that's correct.
Thank you.
Follow up to that, counsel. Are you still pursuing the hold without bail order, or do you intend to withdraw it when you go down, if this case goes back down?
No, the state fully intends to withdraw it. I don't believe I have a legal basis to pursue it at this point.
Okay, well, with that in mind, my question is, other than remanding this case back to the trial court, isn't it moot up here?
Yes, I think so.
Thank you.
And on that point, absent any additional questions, I have nothing further to add.
All right. Mr. Appellant's counsel, please.
I have nothing further on rebuttal, Your Honor.
Okay, please call a conclusion of the hearing.